Is about eviction. All right, what's going on, y'all? This equity discussion is about eviction remedies. My name is Amir Samael. Let's get the legal stuff out the way. Disclaimer, this is not legal advice. I'm not a bar card licensee, enrollee, nor is this advice, nor is this an offer or solicitation to be your personal lawyer. This is for information and entertainment purposes only. You need to do your own research, do your own due diligence. In fact, there won't be pretty much any legal advice at all, only equity here. All right, so eviction is about possession. It's not about a debt, especially at the point where you're in court, unless the landlord decided to grant you the grace, aka accept your money instead of evicting you. Or perhaps a judge just, you got some sob story or you got a good story or whatever it is, and he decides to grant you grace as far as the money. But make no mistake, when you get into court about an eviction, it is about possession. There we go. Typically, people fell out evictions because, again, they try to go at the debt, or well, not title, but they usually go at the debt and they're trying to do some type of remittance. They're trying to do um, some type of tender of payment, just whatever it is, right? First off, landlord's not gonna accept that shit. It's probably just a regular person like us. So he don't know, you know what I mean? Like he's not gonna know what to do with that. Um Second, it's like when he or she, when the landlord refuses it, you don't know how to enforce it. So that's another issue. Gotta focus on possession. They're evicting you. It's a writ of possession that they're filing. That's how the court case is starting. So a lessor is essentially someone who grants a lease to someone else. As such, a lessor is an owner of an asset that is leased under an agreement to a leasee. The leasee makes a one-time payment or a series of periodic payments to the lessor in return for the use of the asset. And so this is essentially this and the landlord tenant relationship is what you're going to be dealing with when it comes to like houses, cars, apartments, hotels, whatever else we can think about here. And so if you didn't catch that, it's for cars too. I just didn't put it out there like that again because I wanted this class to be somewhat smaller. The basis of a legal relationship between a landlord and a tenant is grounded in both contract and property law. The tenant has a property interest in the land, historically a non-freehold estate, for a given period of time before the property interest transfers back to the landlord. So first off, the landlord and tenant is grounded in both contract and property law. So we know that in the public you're contracting under the Emergency Banking Act, war powers. Basically, is military. You're contracting under military occupation. We don't want that. We need private relations. Then I also want you to see how so the tenant has a property interest in the land for a given period of time before the property interest transfers back to the landlord. So if you're in the correct position, the correct status, and at the time of possession, you're holding the highest interest, there's nothing left to be said. And that's why this works. Unlawful detainer, or UD for short, refers to the name of the official court complaint that a landlord makes when they want to evict a tenant. It's called the unlawful detainer because the landlord is claiming the tenant is unlawfully detaining or holding back the property of the landlord. So when you get evicted or when they're trying to evict you, this is the first court hearing that you're dealing with. Always. Unlawful detainer. I'm saying again, you cannot talk about anything else at these court hearings except for possession. Has to be about possession. Anything else, you're going to get railroaded. I promise you, you're going to get railroaded. If you've never been there, I have. It's a line of people just getting railroaded. It's not fun to be there or to look at. So again, we're dealing with landlord tenant, leasee leaseor relations in the public. We want to extinguish those public relationships. We have to withdraw and redeposit the property. When we do that, we extinguish the public relationship, and all that's left is trust relations and confidence. And that's with anything, any property. All property is in the public status. You as a private, all property in the public, basically it's in the public because it's an imperfect title. I mean, someone in the private didn't perfect the title, or basically it has not been, the title has not been perfected in the title, in the private. So you as a private American always claiming the titles, withdrawing it from the public and redepositing it on special deposit into your private trust. So I'm gonna tell you some key things that need to be in your trust. The goal here is to create a trust and serve it on the landlord, making him a trustee. Trustee has to perform by what the grantor says. And we're going to go over all these relations. If you're not familiar with them, we're going to touch on them. But we are creating a trust to convey to the landlord, making him a trustee to settle this matter for our behalf. And what he's going to do is He's withdrawing the property from the public and depositing it into the private for our benefit. So establishing trust for possession, you need to state the jurisdiction and venue of the trust is in such whatever county you live in, um, nation of whatever state you live in equity of the United States of America, Court of Chancery under God. Those are all key. You see, that wasn't pursuant to any U.S. code, any statute, or nothing like that. It's equity. That's God's law. The trust corpus. The grantor beneficiary's specific intent and purpose of the trust is to withdraw property from general and public creditor-debtor, landlord-tenant relations into the realm of private special trust relations regarding property. That's literally what you want to do with all property. You see, creditor-debtor is a public relationship, if you hadn't heard me say that before. This is why I don't speak about being the creditor, because we're not the creditor. We're the grantor beneficiaries. Number two, kind of just said that. Three, to merge the legal and equitable titles of the property to vest in the beneficiaries. That's essentially, so when you merge legal and equitable title, you have absolute title. To identify beneficiaries as a true real beneficial interest holders in due course of real property. It's basically saying you the owner of the property. Take a look at number 6. To change the nature and character of the property from being a marketable security to being perfected, good, and lawful title. So everything in the commercial public, those are marketable securities. Sounds good, right? Sounds good, but that's the trick that the Jesuits play. They'll say good and good marketable security or something like that, but it's not perfected. And when the titles aren't perfected, the system, the public, they feed off that. The whole entire commercial realm, commerce, it only exists because people don't do equity. They don't know it, including myself. I'm not just going to say I'm just a master at it. I'm a master student, but obviously we didn't grow up learning any of this. We're trying to make it a way of life and pass it down. Then to recoup grantors, beneficiaries, financial assets, real and intangible property linked to the property. So recoupment of the rents that you paid. Now, are you going to get that? More than likely not, unless you just really try to enforce it, which you can. But just in the lower court, judge is really just going to ask you, what do you want to do? Don't get greedy. I usually just tell people to say, you want to stay for a year or you want to stay until the lease is up. To correct the public record to reflect the true owners of the property, which again is the beneficiaries, that's us. To record the lawful owners of the property, same thing. To extinguish property's debt and liabilities through the application of merging of the legal and equitable titles of the trust. To extend immunity to trustee for performance of a purely private, non-commercial, non-statutory, lawful function ordered by grantor's beneficiaries. That's important to give immunity or indemnify the trustee, because essentially it's kind of like, to keep it simple, they got orders on the public side. You know what I mean? They got orders and things that they're supposed to do. Otherwise, they get in trouble. So as private Americans, as the true source, it's like we grant them grace. We basically saying, hey, it's cool. You got to do this for me, but hey, it's cool. Let your peoples know it's cool because I said so. As a private American. And to allow for the grantor's beneficiaries peaceful possession of the property, obviously to not be harassed or, come in and, try to get evicted again, which that could possibly happen, but they might go a different route with it. Um, it could be it could be a few different things, but it don't matter what they come back with. You're still doing the same thing. Need to put in there the trustee duty. So the duty of performance of the trustee is to discharge the trust by execution of the following. Again, merge legal and equitable titles of property by transferring legal title of the public record to the grantor's beneficiaries and affect the extinguishment of liens and securities along with it. So if you haven't figured out now, this is literally severing the relationship, the public relationship. So the interest that the landlord had, that he thought he had, that was higher than yours, it's no longer. He's no longer the owner of the property. Truth be told, you could probably hold it as long as you wanted to. And we learned this because a woman did this with a hotel room. And let's see, is there anything else I want to touch on? All right, this is pretty much reiterating the rest. What I already been through, really. But make sure you literally put this in your indenture. So we're just going to touch on a few positions about the trust and what it is and everything for people who don't know. So what is a trust? A trust is like a special container that someone sets up to hold things that are important to them, like money or property. When someone creates a trust, they put their belongings into the container and then give the container to someone else to take care of. This person is called the trustee. The trustee has an important job to do. They have to follow the rules that the person who created the trust wrote down. These rules explain how the things in the trust can be used and who can use them. So let's say that someone creates a trust to hold money for their child's education. The rules might say the trustee can only use the money in the trust to pay for the child's school expenses. the trustee can't use the money for anything else like buying a car or going on vacation. So the person who created the trust is called the grantor or settlor. And the person who will eventually receive the things in trust is called the beneficiary. In our example, the child who will use the money for their education is the beneficiary. So overall, a trust is a way for someone to make sure that their belongings are used the way that they want them to be used, even if they're not around anymore. It's just like leaving a set of instructions for someone else to follow. Irrevocable versus revocable. So there's many different types, but they all fall into one. So revocable trust can be changed at any time by the grantor during their lifetime as long as they're competent. Irrevocable trusts usually can't be changed without a court order or approval of all the trust beneficiaries. This makes an irrevocable trust less flexible, but it has the best protection from creditors. What is a grantor of a trust? A grantor of a trust is a person who creates a trust and decides how their assets should be managed and used for the benefit of someone else, called the beneficiary. Think of it like a present that the grantor gives to the beneficiary to make sure that they're taken care of. The grantor picks someone that they trust, called the trustee, to make sure the present is used in the way the grantor wanted. What's a trustee? A trustee is like a special helper who is in charge of making sure the trust is used the way the grantor wanted. The trustee makes sure the beneficiary gets the benefits from the trust, like a birthday present, and make sure the rules set by the grantor are followed. It's important for the trustee to be honest and responsible because they are taking care of something that was given to the beneficiary by the grantor. And I'll add, can be held personally liable if they're not responsible. And if you haven't figured out what a beneficiary is yet, let's go over that. So let's say you have a favorite toy that you love a lot. You want to make sure your toy is taken care of and goes to someone who will love it as much as you do after you're grown up. So you give your toy to your mom, who you trust a lot, and tell her to keep it safe. Your mom is like the trustee taking care of the toy for you. The person who gets to play with the toy and enjoy it when you're all grown up is like the beneficiary. They get to have fun with the toy because you wanted them to have it and took care of it for them. What is a grantee of trust? Grantee is like someone who gets a special gift that is kept safe by another person. The person who keeps the gift safe is called the trustee, and they make sure the gift is given to the grantee at the right time and in the right way. The person who gives the gift is called the grantor. Just like when you receive a gift, the grantee can use a gift to do something special like buy a tour or save for college. So I guess to keep it short, it's like the grantee is really the one receiving, you know, a trust or I mean receiving property, receiving whatever. So when you're doing your when you're doing your conveyances, your deeds, it'll be it'll be grantor transferring something to grantee. Then the grantee needs to do an acceptance, to which I'm setting up a Dropbox. You know, you guys, I have templates. You'll be able to see exactly what what all this looks like. So what is perfecting title? Deed of acknowledgement, acceptance, and receipt by grantee for absolute estate and account number. All right, so I made this more specific to what we'll be doing to establish a trust. That's why you got that statement right there. So essentially, when you're establishing the trust, you need to do an acceptance on the account number so that you have the highest interest in that account number. So a deed of acknowledgement is like a special paper that says you own something like a toy or a piece of land. When someone gives you the toy or the land, they sign a special paper to show that they are giving it to you. Then you sign the special paper to show that you accept the toy or the land and that you know you now own it. This special paper is like a receipt because it proves that you have the toy or land now. So a lot of times we get papers, right, with our names on it and we don't sign. Like on the deed, or let me give another example. When you have a baby, you don't sign. You either don't sign next to the print or you don't sign correctly. Essentially it's plenty of papers that we get from different entities with our names on it that we never sign next to our name. We never do an acceptance saying that, acknowledging that, we just received something, that we're okay, we're good with it, sign off on it, everything is copacetic. Think of it in terms like very, 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 very basic. If somebody gives you something, right? Or let's say if somebody is trying to give you something, they're trying to give you, like they're trying. Why are they trying? Because you have to either accept it or reject it. When you say, yeah, I'll take that, that's you acknowledging it and accepting it. Sign off on the paper. Then that's perfected title. What is a notice of interest and trust? Notice of interest is you coming as a grantor settler establishing an interest in all of the sub numbers master number. Again, that we'll get to that in a minute. But that's the account number that you establishing your the highest interest in for your trust. So notice of interest is like a message to everyone that you own a special thing like a toy or money in a bank account. When you put a notice of interest, it means you're telling everyone that the toy or the money belongs to you and that you have a right to it. It's like putting a big sign that says, this belongs to me. This helps you make sure that nobody takes your toy or money without your permission. What is a statement of interest? The statement of interest is the evidence. So a statement of interest is like a message that says you got a toy or a special thing. It's like a receipt that shows you took ownership of the toy or a special thing. This message is important because it proves that you got the toy or the special thing, and it makes sure that no one else can say that they own it or took it from you. But all in all, statement of interest, I want you to think of it like it's your evidence, your proof of something. proof that you did something. What is a conveyance and trust? So a certificate of title for a deed of conveyance of property is like a special paper that proves who owns a piece of land or house. When someone buys a piece of land or a house, they get this special paper to show that they own it. The special paper is like a diploma or a trophy that shows that you would get for winning a race or a contest, but instead of showing you won, it shows you own something. The certificate of title has the names of the people who owned the land or the house before and the name of the person who owns it now. The special paper helps to make sure that no one else can say they own the land or the house, and it helps to keep track of who owns it. So again, that will be going from the grantor to the grantee. And the deed of conveyance is truly how you fund your trust. A lot of people just like to put shit on Schedule A or Schedule B, whatever, or however they do it. But that's bullshit. Don't do a real conveyance so you have a real deed. Got real proof. It's recorded on the land. That's going to hold more weight. What is an indenture of a trust? Indenture of the trust, aka the law of the trust. An indenture of trust is like a set of rules for a special savings account, just like how you have rules for your piggy bank. A trust also has rules that tell the person who is keeping the money safe, which is a trustee, what they can and can't do with the money. The indenture of a trust is a written document that sets out these rules, like who the money is for, when they can use it, how they can use it. The indenture of a trust makes sure the money is used in the right way, just like how the rules for your piggy bank make sure you save your money and use it wisely. And acceptance by a trustee. That's kind of self-explanatory. We just went over acceptance, and trustee needs to accept a position. Otherwise, it's not valid. And you can't force someone to be a trustee. But at the same time, equity maxim, a trust will not fail for want or lack of trustee, meaning you end up in court. The court will order someone or some entity to be a trustee for that trust you created. So it could literally just be, hanging around waiting for a trustee position to be filled by the court. What's a certificate of trust? Certificate of trust is like special paper that shows you have a special job. When someone is in charge of taking care of something important like money or property for someone else, they get a certificate of trust. Certificate of trust is like a diploma or certificate you would get for finishing class or learning a new skill, but instead of showing what you learned, it shows what your special job is. Certificate of trust has the name of the person who has a special job, and it says that they're in charge of taking care of the money. Special paper helps others know who in charge and that the person has a very important and responsible job. So certificate of trust is definitely going to have who's the trustee, nature of the trust, whether it's irrevocable, revocable, how it's settled, how it's funded. What are the key components of trust? Inequity, for a trust to be valid and enforceable, it must have 5 key components. I know they tell you 4, but it's 5. So the existence of a trustee, the existence of a beneficiary, some type of trust res, not a relationship involving merely personal duties. The passing of title of the property to trustee to hold title for the benefit of another. and grantor has parted with the total control over the property of the trust. Acceptance of trusteeship and holding certificate of trust. Most trusts fail with this component. A manifestation of intent to create and express trust relationship. So with these 5 components are essential to creation of a valid trust in equity. Without one or more of these components, a trust may be considered invalid or unenforceable. Number 4 is huge. Make sure you pay extra special attention to that. All right, boom. So red register mail labels. This is what I need all of you to go and get. And get them from the post office. You might have to go to the main post office. Now, 9 times out of 10, they're not going to just give you, they're not just going to give them to you. You got to finesse it. So the way I tell people to do it is you got to tell them, hey, I got a business where I do a lot of international shipping. Like put hella emphasis on a lot. I mean like a lot of international shipping weekly. I need some red registered mail labels. I tried to order them online, but they sent me these. I need the ones with the numbers on them. You can even say, I tried to order them 3 times and they sent me these each time. So I can't order them online. And I do a lot of international shipping. So can I get a roll of them so I don't have to keep bothering you about it? Try to befriend somebody at the post office because you know in this space you'll do a lot of mailing stuff out. You're gonna need things. Then when you start finding out more knowledge about the post office, you're gonna want to talk to somebody about it and get things done while you executing. So it's always better to befriend these public servants, find one that's cool that you like, just build a relationship with them. They're gonna become your advocates. And so this is the account number that you'll be establishing your interest in. This number will also be your trust identification number or the name of your trust. So establishing a trust, you need to mail that red registered mail number to yourself as grantor and accept as grantee. Again, the number is used for the trust ID or the trust name, the one that's being served on the landlord. You need to create the indenture, but do not record the indenture. It's private. Believe it or not, there are people who do it. If you do that, you just made your private trust public. Let's see. Need to record NOI, SOI, which is notice of interest, statement of interest, the acknowledgement, acceptance, and receipt. Um, Basically, that's a perfecting title and a number. special notice of deed of conveyance. That also needs to be recorded. Then you want to serve the entire trust on the landlord, and you want to give notice to the judge in chambers. Then you want to post a special notice. That same notice that's going to the judge's chambers, that notice needs to be posted on your home door. Every time you send anything out, you need to always make sure you use USPS forms 3811 and 3817. If you don't know what those are white and green cards. If you want somebody to sign for it or, um, restricted, the green card and certificate of mailing, that's the white one. You need to always use those because in court, that's going to be your evidence. That's your receipts. You like receipts, right? So got to bring the receipts, show the judge like, hey, not playing no games today. I got the receipts, cuz. Um, all right. So to reiterate, unlawful detainer, that's your first court hearing that you'll be going to. Have to make it about possession. Don't talk about anything else. Straight trust law here. And matter of fact, let me go back. So just so I make this clear, the registered mail number, got to mail that to yourself first, right? And establish your interest in that. Establishing the interest in that number, that's why you're going to record the notice of interest, the statement of interest, the acknowledge the acceptance, and special notice of deed of conveyance. All that is establishing your interest in that account number. Then you obviously need to create the indenture so that the trustee can know the purpose of the trust and what his duties are. And obviously the trustee is the landlord. So after you record everything and you create your indenture, right? Now you have a trust. And you need to send it out to the landlord, making him a trustee the moment that it is delivered. You can definitely reject. If you want to give him 7 days to reject, that would be good. I wouldn't give him anything longer. If he doesn't reject it, then he's trustee. If he does reject it, I just told you, don't matter because equity maximum. Trust will not fail for lack of trustee. After you serve the trust on the landlord, and that's delivered, right? You want to send a special notice of trust to the judge, which we're going to go over here in a minute. And put that special notice on the door, just in case sheriff or anybody else gets pulling up for whatever reason. That's the first thing that you have to do when you get that writ of possession, when they basically trying to take you to court. Then obviously you'll be ready for your hearing. You already gave the judge notice. It's a courtesy. So now you're not just catching him off guard. Now he can become your advocate after he tests you. Make sure you ain't getting nothing off the internet. Make sure you real deal Holyfield. So in your hearing, your UD hearing, trust by parole. So oral trust. You need to express trust law. We say wrap the case up in a trust. Just how powerful trust is. Can just speak it and it's valid. Sure, it should be reduced to, written on paper, but still, it's valid. And I'm going to help you out with how you do that. It's the first time I'm really putting this out there like that. Uh, Most people probably heard of the first thing, but so my name is granted to the court for future return with my interest. So if you didn't know, when you go into court and they call the name up, that's basically the judge stealing your name, stealing the estate. So what you're saying is, hey, I grant you my name, but all the money that you make returns to me. Or I should say all the interest returns to me. Already wrapping them up in the trust right there. Probably gonna say something like, understand the legal significance of that. Bet you don't, because it's not legal. So the significance of this matter lies in equity rather than in legality or at law. In a court of equity, historical recognition of equitable rights means that this matter cannot be heard here due to its purely equitable nature, which presents a conflict or variance of law. Specifically, the equitable rights and defenses involved are not cognizable at law, and the rights being defended are entirely equitable in nature. This is you expressing equity. This is you telling him that, hey, you like like don't railroad me. It's basically you saying like, hey, don't railroad me. Like you can't see my rights, but I got them. You know what I mean? Like we just in the wrong court. Then after that, you can say your name, your first name. Uh, I'm the grantor beneficiary of a private trust, which is a unique matter that requires urgent attention. To protect the interests of the trust, I'm invoking the jurisdiction of a court of inherent equity, as it cannot be properly addressed in a court at law. In cases where the rules of law conflict with the rules of equity pertaining to the same subject matter, the latter shall prevail. And my friends, you understand why we study exclusive equity now. Pomeroy tells us In cases where the rules of law conflict with the rules of equity pertaining to the same subject matter, the latter shall prevail. Equity always prevails. This is why we study it. And so again, what I'm telling you right now are things that you need to say. So you can even, you know, put it on paper and take it with you so you don't forget it or memorize it. Get familiar with it, so you just know what you're doing, what you're saying, and you can just uh just talk it whenever you need to. Come second nature. Does this court have authority over private trust? Does this court of does this court have constitutional judicial power? Judge, do you disclaim the trust? All these are loaded questions, by the way. Yeah, all of these are loaded questions because if they acknowledge the trust, then boom, we automatically in equity. The equity governs trust. Ain't no way around that. If they don't acknowledge it, um, that's really a breach of trust. They could possibly just ignore it. But at the end of the day, if they ignore it, they didn't disclaim it, which means still be a trust. Let the record show. Judge didn't disclaim the trust, so it must be a trust. Judge is never going to disclaim the trust, which further lets you know that we're truly dealing in trust. As the record shows, there's a private trust in which an individual not cognizable by this court has rights to property, title, and other interests. These proceedings threaten to irreparably damage the rights of a beneficial interest holder in the private. Again, these are all things that you need to say at your UD hearing. In light of these urgent circumstances, the defendant is requesting that this proceeding at law be dismissed and instead be transferred to a court of special equity where the rights of a private beneficiary can be properly recognized. There goes your motion to dismiss if you like that. The private trust that has been established meets the four primary elements necessary, or you say five primary elements necessary to be considered a valid trust. Firstly, the intent and purpose of the trust have been clearly communicated to the trustee, which is the landlord. Secondly, the parties involved in trust have been clearly defined. Thirdly, the corpus of the trust have been delivered and transferred to the trustee as a special deposit with specific performance demanded of them. And lastly, the trust has been formed through transfer, assignment, declaration, and by operation of law. The jurisdiction of equity pertains exclusively to private trusts, while this current proceeding is being held in court at law, which runs counter to the principles of equity. In the event that the judge and the court decide to continue with this proceeding, it should be noted on record that they have been made aware of the established rights of the private party. By proceeding, they are assuming personal liability for any damages that may be incurred as a result of violating these private rights. It's okay to say damages because at this point we're acting as a defendant in a public capacity and we're referring to ourselves in the private as a private party. Don't forget that. Don't go into court. It's essentially like you going into court and telling them, hey, you got somebody in the private that got higher interest now. We need to pay attention to that. You and the judge know, talking about you, obviously, but in a whole different mode in court, that's public. Outside of court, then it's private. Once you go into that court, it's public, unless you're in equity. So, my friends, you have you have established your interest in that private account number, right? You have did your indenture. You served the landlord, made him trustee. You have put the special notice on your door and sent it to the judge in chambers. You have went to your UD hearing and you expressed trust by parole. You wrapped the case up in a trust and you moved you motioned to dismiss or basically moved it to trial, right? So now headed to trial. That's a good thing, by the way, because otherwise you just get railroaded. It's either trial or you get railroaded. That's it. Or obviously you get the relief, you know what I mean? But yeah, so if you go on a trial, what you need to do is file a bill of Kia Timid into judges' chambers. So a bill of Kia Timid is derived from the Latin phrase, which means because he fears. It grants a party equitable relief from the court for a probable harm to their specific right or interest. It's similar to an injunction. However, unlike an injunction, it only prevents future infringements of a right and cannot redress past infringements. So essentially, you are going to come up with a bill of Kia Tamit, and you're going to send that to the judge's chambers saying, hey, my property needs to be protected. I fear I'm going to get railroaded here. Chambers is private. You're saying this as a private American, even though in that courtroom, you're a public defendant, U.S. citizen debtor. Send this to judge's chambers. Then you go to your hearing, and the judge to basically tell you or ask you, what do you want to do? Or he might say, you want to give a testimony, let both of y'all give a testimony. But essentially, you're expressing what you want to do, what should happen. You can go back to trust by parole until he asks you what you want to do. That's usually what I tell people. Um, then essentially, yeah, that's it. Like he's gonna ask you what you want to do. Tell him you want to stay for a year or however long, or you want to stay until the lease is up. Just don't get greedy. But that's pretty much the entire flow of things. And like, let's go ahead and go to the next page. All right, so order of flow. So establish interest in the registered mail number. and create your indenture. Then you want to serve the trust on the landlord, making him her trustee. Then you can issue a quo warranto to judges' chambers along with an affidavit of truth and a special notice of trust. This is actually exactly how we did it in I think one of those testimonials I showed you, or that's on my page. Then you want to go to the UD hearing and express trust by parole. Wrap it up in a trust. Then you can send a bill of exceptions to judge's chambers if you would like. Then go to the trial hearing and express trust by parole. I forgot to add in there. Shoot. All right, before I send it to you, I'll add it in there. But essentially, you need to before you get to before you get to trial, when you are doing your bill of exceptions, if you decide to do that, you for sure need to do the bill of Kia Temet. I can't believe I forgot to put that in there right here. So again, watching this, going back through it, you want to know the order of flow. This is correct. You just need to add in um, after you go to your UD hearing and express trust by parole before you go to trial. Before you go to trial, you need to submit your bill of Kia Temet into judges' chambers saying that you need to protect my property. Then you go to trial hearing and express trust by parole again, or yeah. Then if you lose your UD or case, or you lose at trial for whatever reason, you messed up, or just railroaded you, do a trial de novo or writ of error in appeals, like ASAP, like the same day you lose, go file it then. Don't waste any time. All right. There we go. All right. Actually, let me see. All right, we're about to go into that's pretty much that is it. We're gonna go into Q&A here in a minute. Give me just a second. Actually, I'm gonna go ahead and knock this other part out too. All right, Chat GPT. Oh, okay. All right, so I'm gonna go to this one and sign up for the 4.0 version. I'm gonna go here in a second. So it's a list of prompts. I got a few more that I didn't put on here. But these are some of the prompts that I use. You can literally copy and paste these. This will help you understand more of what you're doing. This will help your vocabulary. This will help your writing. Uh, Save you time. You'll feel better about addressing the judge. I can go on and on about this, right? And so let's do this. Let's just go. Ooh. All right, trying to let me in. All right, so let's say y'all can still see my screen, right? Let's see. Type in the chat. Y'all can still see my room. I mean, y'all can still see my screen. Bad. All right. So I'll be playing around with this mug a lot, man. A lot, a lot. But so let's say, all right, type actually explain. Let's see what it says. All right, imagine you're playing on a playground with your friends. You're building a beautiful sandcastle. Oh man, what the just happened here? All right, there we go. You're building a beautiful sandcastle, but you see a big kid nearby who looks like they might come and knock it down. You're scared that if the big kid comes close, they'll destroy your sandcastle. So a bill of kid Temet is like asking a teacher to help you before anything bad happens. The teacher makes sure the big kid doesn't come close to your sandcastle and cause any trouble. This way, you can keep playing and having fun without worrying about your sandcastle being ruined. So a bill of kid Temet is a way for people to ask for help from the grown-up in charge, like a judge, to protect them from something bad happening, even if it hasn't happened yet. It's like having a shield to keep you safe from the things you're afraid of. Boom. So is that not what I just explained to you guys? You are sending it to judge's chambers so that you can receive equitable relief, telling him, hey, need to protect my property, which is going to be the house that you rented from the landlord. Hey. So, yeah. Boom. That's funny. You're funny. All right. So let's try something else. Let's do. Let's say. Oh, let's say type up. A Hmm, let's say, look at that, right on the spot. Just typed you up your whole template right here. Literally, you can use this. And you might have to change some things or whatever, to really fit your situation or how we want to say things. But that's like with any template. And we can say, watch this. Say, a add on supporting memorandum of law. Blessed Pomeroy. Uh, make sure we have a shake. Actually, I'm gonna save that. I'll just say this. Like this is what you want to do. You see, I'm not referring to any statutes, codes, none of that shit. I'm name dropping from the books that we read because these people are master at equity and trust law. They're highly respected in court. Henry Gibson is highly or was and is still highly respected in Tennessee. When you start name dropping these people, they know you really reading. They know you're not just on no bullshit. Just like that. You got a memorandum of law. Got a whole template here. Let's see what else I want to do. Let's say type up a trust for possession of property with a Shakespeare tone. My shadow hath been cast. By this parchment I bequeath. Hey, by this parchment I bequeath the property to thee, dear trustee, until time doth come. If you're wondering if I've ever sent one of these out, I have, specifically with the Shakespearean tone. Or I'll be like type up one from the with a tone from the 1700s. And I'll just tweak it for whatever I need it, you know. You can say type of, let's see, what else? This is mainly how I use it, or I might do something like to say something like I might do this and reword the following and make it more simple so that my 5-year-old can understand. Let's see. Well, that's what it came with. Um, but so yeah, I mainly use it for the to do these up here though. And I'll just I'll tweak it by whatever I need to. Just kind of depends on what I'm doing. I think there might be one other thing. Started to not even really put this out there, but I figured it could really help people. I know people not using. Well, I know lawyers are, but outside of lawyers, like I know people not using Chat GPT like this for these templates and stuff. Um, so you can have edge on the game. Oh, that's what I want to say. So I'm heavy on the make it personal when doing this, especially when it goes to a judge, because like they already want to see if you pulling shit from the internet and stuff like that. In fact, from what I hear, they got a whole like software that can tell if you actually got something off the internet or not. So with that being said, it's good to reword things or just to make things more personable, especially when going to a judge like that. Just make it feel like they your words instead of Chat GPT. That really be the main thing that I focus on. Um, and I would advise you to, if there's something that so I'm gonna have templates in the Dropbox for y'all and some reading material. But I would encourage you to get Chat GPT 4.0 version is like $20 a month. And the other version cannot do this. I tried it. It cannot do this. And then I suggest you try doing all of your own templates using ChatGPT. Um, all right, that's pretty much it. We're gonna do a Q&A. How do this? This yeah, okay, that's not bad. All right. All right, bet. So we're gonna do Q&A now. I'm gonna give y'all it's a small class, but I'll give y'all probably like 30 minutes and if we need it. Um let me see who's on here. Ali Bali, what's going down?
Hey, peace, peace. Thank you for this class. This was dope.
Hey, not a problem. We're gonna do Q&A now. Why don't you help me out with these questions, please?
All right, no doubt. So yes, so if anyone has a question, please raise your hand. We have Larissa. You can put your hand down. I'm sorry.
Everybody better have questions. If not, no, I'm just fine. I must have did a good job explaining it. If you ain't got questions.
You did an amazing job. This is the most amazing thing I've ever heard. I can't even. And thank you for joining this class. A couple of questions. So, when we're doing these documents, there's this specific format that the courts require, or can we just, I mean, will they send it back if we don't do it according to their format or?
So equity is not about format. Like
Okay, perfect.
now, now procedure can get in the way for sure,
Mhm.
for sure. But what I just told you, like you don't really have to worry about procedure. Like if you're going to appeals, then yeah, but like you're not doing anything that requires like serious like studying of procedure. It's not like you're going to Supreme Court or you're trying to file or I mean it could be numerous other things, but you're good
Okay.
without so you don't have
Okay.
to.
Well, with my situation, because it's I've had an unlawful detainer, but it got dismissed. My house, my parents. This is my parents. My parents quit claim this house to me before it got sold at a trustee sale, and I was, doing all kinds of things, expressing to the trustee prior to that, about my rights and that, and then when I got, a 30 to 90 or 390 day to quit, I, send it to the clerk of the court and the judge, and they said I didn't have I mean, I did it with the registered mail method. I kept the green receipts and everything. And they said that they came back and said um, I didn't have a process notice of service. I didn't do notice of service. And when I got that back, I didn't know how to respond. So I just wrote across their document, I do not consent to this procedure. Um, you know, uh, no consent, no contract, blah, blah, sent it back. And then they went full on into writ of possession. I didn't
Yep.
know what to do from that point on. So I just, my
They just
daughter,
wanted you to serve the party.
huh?
They wanted you to serve the other party.
Oh, well, I did do that. I
Yeah,
did.
but you didn't tell the court you did it.
Oh, well, I showed it to, on the top, I put to the court and to the lawyer. I mean, put two addresses at the top.
Nope. You gotta have certificate of service. All
Oh,
you needed. That's probably all you needed.
oh, wow.
A lot of times we gotta slow down and I get it. because we're all just like F the courts, F the government. They
Uh-huh.
they don't. I get it. I truly get it. But when you get into equity, you truly have to change your perspective. The judge, matter of fact, all of them, they're public servants. We all know that, right? We all feel that they should be working for us, right?
Right.
That only happens in equity.
Uh-huh. Right.
Only happens in equity. They become your advocate. They want to help you.
Uh-huh.
Especially the clerks, they'll get to learning themselves because a lot of times they've been there 20, 30 years, never seen nobody come through these doors talking how you talking. So now they like, hold on, you on bullshit. But then when they see you really got something, they trying to learn. Oh, it's whatever you need, whatever you need. In
Wow.
fact, when you get to talking like that, they're gonna know who you are when you step in the court. I mean, when you step in the building,
Mhm.
they're gonna already know who you are.
Wow.
You're special. When you do equity, you're special.
Wow. Yeah. Oh my God, that's so amazing. Would it be too aggressive to say, these proceedings are damaging a trust in the private, and should you move forward, you are commingling the public with the private, and you may be held liable for a full accounting inequity.
That's fine.
Is that fine? Would
Yeah.
they like get so angry and to try to
I
do
mean, they're
some?
gonna do what they do, but at the end of the day, it's about you preserving your interests on the record.
Okay, and
So
they're
that's like people have a hard time with that. Not saying you, but like in general, people have a hard time with that. But it
uh-huh.
just kind of goes back to just putting on a show. I know it's kind of like real life, but it's still a show.
Mhm.
Like, I'm
Yeah,
trying to say,
also, I bought your a land trust, and it had pretty much I bought it for the land patent information, and I had studied Ron Gibson's. Will that come into play with my situation? Because that's supposedly that's the highest title, but you have to take it to the Supreme Court to get recognition. Or but supposedly the letters patent, and I put that on a grant deed, and but I didn't use that at all because I didn't know how to move with it. But would that be good to even put on my documents?
um, I mean, you can't never go wrong with that, honestly.
Okay. Okay. Oh, awesome. Awesome. Thank you, Amir.
Yeah, no problem at all. No
Thank
problem at all. Next question.
All right, we have William. You can put your hand down, please.
That might be somebody else. William or what was it, Mel maybe?
Oh, you can unmute yourself, William. I'm not sure if you still have a question. If you don't have a question, we have Shayna.
No, I still have a question.
Oh, okay.
Okay.
All right then.
Uh, to extinguish the public relationship, that is like when you're so that you have to serve him with the papers of the trust,
Yeah,
the
so
lender
that's established.
with the letter. Okay, and so he doesn't have to accept it, but in court they will assign a trustee then
Right, because the trust will not fail for a lack of
because lack of a trustee. Okay. And I had a thing about the beneficiaries. If you have multiple beneficiaries, they all just have to accept.
so yeah, all beneficiaries should accept, you know what I mean? But that's kind of irrelevant as far as this situation goes.
Okay.
Like they never have to know who your beneficiaries are. The only time your beneficiaries are even going to be recognized are like in camera in chambers. Other than that, I mean, nobody's ever going to see your private trust.
Okay. You had mentioned something about it in the private trust. I didn't know if that had to be in your private trust when you were going to this type of court or not.
Not for this one.
Okay. Well, thank you very much.
No
This,
problem at all.
this has been a great class.
Thank you. Thank you. I appreciate it. Next question.
All right, thank you. Shayna, you can unmute yourself and put your hand down, please.
Hey, good evening.
Hey, what's happening?
So I don't necessarily have an eviction like situation, but I understand this is about possession.
Yeah.
So I had sold my car online.
All right. You came in here because you knew it was about possession. See, the rest of these people who didn't come, they weren't smart like you.
That's cool. So this was like they party with a local tow yard to come and pick up the car. So I don't know why, but I had changed like the carrier because of the scheduling. So the previous carrier actually came and picked up my car. So they didn't get the title from me or the key or anything. They just took my car. So eventually they did pay me, but at this point they lost my license plate and they're saying they mailed it to me. So I just want my car back. And I kind of don't really understand how like I'm interacting with the company, even though, you know, I'm sure if I read this over, I may
Hold on.
understand.
You said you got paid. You got paid for what?
I did get paid for the car.
You're not getting that car back.
Even though I have the title still.
You got paid for the car.
So my license plate though, because they picked it up like
Well, this is what I want you
improper.
to understand. So, and this is just in general. So, I personally don't chase cars like that. Especially if you've already been paid. Not saying it's your prerogative. So if you want to go after it, if you want to study this information and execute and try to get your car back, then I'm not saying you can't do it, or you know what I mean, you can't attempt it. Equity provides uh, it's very peculiar in the relief that you can receive. I'm just saying you might want to choose your battles because yeah, it's equity, but it don't mean you don't have an uphill battle as far as that's concerned, because chances are you haven't done any equity. So you'll have to basically start doing it and start trying to get, relief. But I'm going to tell you, equity is going to look at you have been paid for the car.
Mhm.
The equity is about making shit fair. So unless you can plead to in a proper manner while you're still owed, then you running in circles. So
I don't necessarily want my car back, but I did want my plate or to be, for them to pay for it. That's,
yeah, I
I guess.
mean, and that might be a conversation that you might study this information and just call somebody and have this conversation with them. You know what I mean? Like start talking like you're a private American. I mean, I don't know exactly how that conversation is gonna go for you, but I mean, just calling and trying. I mean, a lot of times people get the results that they want. If they're calling and actually expressing, equity or trust law or, surety shit, then
Mhm.
they get the relief they're looking for.
So, I I like how you explain it, even like how you ask ChatGPT to explain so your 5-year-old can understand. It's kind of like storytelling. So I'm kind of having like maybe a little hard time understanding how I'm like interacting with the company, I guess, because I understand I will go to court for, I don't know. If you understand what I'm saying, maybe you can like fill in.
I don't understand what you mean when you say you don't understand how you interacting with them?
Like, I would go to the court about the company. Would I just mention them at the court, you know?
Well, if you're trying to get your car, I mean, so you're trying to get them your plate back, or you're trying to get them to pay for it. So you might want to deal with them instead of the court.
Okay. So yeah, mostly I'm talking in general at this point about like just dealing with any company. I'm kind of having a hard time just understanding, you know, if I would have to go to court, if it would be at court, or I know you did mention things can be done verbally and you can find relief that way. So I guess I would just be having a conversation as a private American with the company themselves. And then if it's a court matter, I would be at the court.
Exactly.
Okay.
Yep. You
Okay.
always want to deal with the company first. It's just like due process, you know what I mean? It's kind of, you know what I mean? Like, how fucked up would it be if you just ended up in court? Like,
Okay.
like if me and you had a problem, you just ended up in court. Like, damn, wouldn't you be like, damn, that's fucked up. You ain't even,
Yeah.
even call me or email me and just like, damn, you know what I mean?
Mm-hmm. All right. That's I guess that's pretty much it. This was very insightful.
Thank you. I'm glad you guys enjoyed it. Thank you. Thank you. Thank you.
Welcome.
Next question.
All right, Eric, can you put your hand down and unmute yourself, please?
With the federales. Yeah, we got the federales in here. What's going on now? Nah, I'm just playing. See, you have to come
We
back.
have to unmute him.
Yo,
Hello, can you hear me?
my boy. I have to come back to you. Yeah. Next question.
Okay, Alexis, can you unmute yourself and put your hand down, please?
Yes. So,
My bad.
okay. So first of all, I just want to say thank you so much for this class, because it was just very eye-opening. And for my situation, I guess my question is, since the writ of possession that was placed in October, Georgia had 30 days to pursue the writ, and then they waited until March, the middle of March, to push it. Like I said, when I was out of town, they did that right like the next day when they knew I was out of town. So would I start my process, or should I start this process this way, or should I, because I'm going towards the company regarding the whole case for like all of my items, because like you said, as far as the wrong ways of handling things, I had went a lot of the wrong ways, but it still had got me as far as it did. So I had sent in certified mail to the CEO and the CFO, and remitted payment. I also put on record with my affidavits, saying that I did not owe them, and that the contract was in dispute. So they shouldn't even be, trying to collect or whatever about it. And so I guess my question is, should I, for the situation, the eviction that's already done, should I focus on the suit of the company, or would this be the beginning of the suit? Like, would this help with the suit?
So, they already did it. How long has it been?
It's this happened March 17th this year. It happened. Yep. And then so I kept track of everything. I got all my certified return receipts. The company, they just, no, the sheriff office, I called them because they had not even noted, because I'm like, were they slick and file something and I didn't know, but like nothing was added to the eviction case. Nothing was added like for another week. So I called and asked them, I talked to the head chief and I just was asking him, who was assigned, because I want to know all the parties involved, because I was coming more towards getting their surety number and, doing a whole nother process, because I have corrected my status. My record, my stuff is on record and stuff like that. And they were put on notice of these things. So I know it's so many different avenues with this information. So I guess my question is, should I be just focusing on the suit, or should I secure this part first? Like putting them as a trustee. It ain't about me. I don't even want that place back. But, would it just hold more weight in this situation? This one, I know it holds the most weight in every situation. Equity, I get that now. But in this situation, what would you advise?
Probably want to focus on your suit because, at this point, it's already past the time for you to appeal, really, because I would say that, but it happened over a month ago. So yeah, if you got a suit going, then you should probably just continue with your suit the way you know how to, honestly.
Okay.
Especially, if you was already doing your thing and, like getting traction.
Yep. Okay.
If you're already going that route and getting traction, then yeah.
Okay. And thanks again for everything, especially the training on the AI, because like this is amazing. So that definitely took me up another level with everything. But thank you so much.
No problem at all. Thank you for attending.
For sure.
All right. Thank
That's all.
you. Larissa, could you unmute yourself and put your hand down?
Yeah, thank you. Sorry, I had a couple more questions I couldn't think of at the time. Oh gosh, how do I protect my property for good once should I ask for an injunction or go for a quiet title? Is that in the public?
Protect your property for good.
Yeah, because it was
Irrevocable
told that
trust.
option, huh?
To be an irrevocable trust withdrawn from the public.
Oh, and the process that you showed right now, that would be doing that, right?
Yeah, essentially, for like your own property to
Mm-hmm.
seriously protect it, and yeah, but
I mean,
I don't know how far you are with trust. Like I didn't go in depth with trust.
Right. Well, I created a private express trust with trustees that are the CEO of this country. Would I put it in that one with that private title number?
I don't know
How I structured it?
Yeah, and when you say
I put all,
who are the trustees?
well, at the time it was Donald Trump, Stephen Mnuchin, and John Koskinen. IRS, Secretary of Treasury, and President at the time. Or my Sesta K?
No.
Oh,
So
not that.
not saying so. All right. So when you do your private trust,
Mhm.
and at some point, at some day, do you want to hand it over to perhaps people like that? Yeah, it's not really a bad idea considering who's a better trust protector than the United States.
Uh-huh.
So it's not an entirely bad idea.
Okay.
However, that needs to be something in personam, not just you putting their names on shit.
Yeah. What do you mean?
Meaning like like you having an in persona meeting with a senator, and
Oh.
I mean,
Mhm,
or like somebody he appointed, or you know what I mean, just something to that degree.
mhm. Oh, I see. Okay. Um,
Till then, you need to have your own private trust under equity under Article 3 to
mhm.
you're a trustee of.
I I did establish, I mean, I those were part of the terms of the trust that it was, that I'm, you know, residing in a non-military occupied private estate, that it's under Article 3, Section 2, subsection 1 of the Constitution. And so if they don't, and I've, you know, declared that if, the same thing that, a trust cannot fail for want of a trustee. So that if they are not able to do it, then any, I guess, judge here, would I have a,
Okay, it's not bad.
would I then, and then in that,
Necessarily have that on my personal trust though. That's all I'm saying.
what's that?
So I mean, it's not bad what you're saying at all. I'm just saying at this point, I would not have them as my trustee.
Okay. Oh yeah, for this, you mean this particular one. So I just create a new trust through like I did the first one through the post office. But how do I protect, is an injunction just for the public, or is it for the private as well? Or do I have to keep going to protect the property? Do I have to keep fighting in court to protect it? Or, I mean, like if there's a quiet title action where it's like absolutely known, I don't, I don't know if I should sue for quiet title.
Oh, so are you saying that? I mean, so do you have somebody coming after your property? You have
Yeah.
a on your
Yeah.
property, like
Uh-huh.
still
Yeah.
own property? Is that what you're saying?
Yeah, it was sold at a trustee sale, but it was sold after it was this house was quit claim to me before it was quit claim to me by my parents, and then they still sold it at auction. I expressed to them certain, I had my parents express them certain rules with regard to the land patent, but they of course ignored that. Um, or
So
at least the trustee anyway, the mortgage company.
yeah, okay, I get where you're at now. So
Still in
this
possession. We're
it
still here.
um
And now we've been served with another 30 to 90 days to quit. And I haven't moved on that because I wanted to do it just the right way.
I would personally tender a special deposit for sure. That would be the first thing that I would be doing
Under special deposit to who?
to whoever you owe. Um,
Strange, because the reason why is because they had sent, they had sent this document saying you're not liable for a mortgage debt. And to all successors in interest, you're not liable for a mortgage debt, and any of your assets cannot be used to pay a mortgage debt unless the lender has a security interest in the property as applicable by law. And, I know they gave that as a notice because that's true. We're not liable for a mortgage debt unless we pay it. And because it was also with the bill, and they, are saying that we need to pay it in this account. And so that was an offer to pay it. And so I said, Dad, if you pay this, you're going to be, they're going to get you in contract by performance. Now they'll have you, but if you don't, you know, you won't have performance or a contract. And so he didn't, but they still moved to trustee sale. And so I don't know what would be owed, because before that, I had also tendered what I thought was a special deposit with a closed bank account, my own closed bank account, with instructions to the CEO of Loan Care I'm sorry, Cash Call Mortgage for the special deposit, and that, if he doesn't accept it, there's discharge. But from listening to you, I realized that I probably worded it wrong, because I said, I'm sending this payment for special deposit. So maybe I mixed the words.
yeah, definitely. It's not a payment at all.
Uh-huh.
You need to need to
Like as a quiet title, I mean, could I get, stop?
that's not gonna do it.
It's not going to do it. They don't recognize it, huh?
I mean, I'm not saying I don't recommend it, but that's not. You're gonna need more than that.
Okay. Yeah. How do I just like quash this for good? I mean, where it's like,
You're
It's
dealing with a house, a mortgage. Ain't no if it was just you know what I mean, like if it was just something anybody could just be like, all right, yeah, do this.
mhm. Well, I I claimed the land patent on a grant deed to myself, and then I was thinking of coding the equitable maxims that which is built upon the land goes with the land. And since I've claimed the land, and it's the highest title to the land, that the house or whatever property that they may have an interest in still goes with the land. Would that hold water?
I think so, but you still need to focus on redemption.
Okay, and so do a special deposit to, I mean, it's completely out of the hands of, because it was sold at a trustee sale to someone else, and they've been harassing my family, and I've had to call the police on them like 5, 6 times. They've been coming like mafia style with like
None of
5
that
men.
really matters if you focus on redemption, the equity of redemption. That's what you need to focus on.
Equity of redemption to the court.
To everybody. But yeah, I mean you can tender for a court hearing possibly and express the equity of redemption.
How do I learn about that? Will you have a class, or do I do a private consultation?
I mean, academy, private consultation, you can probably just look it up some possibly. I don't
Okay.
know.
Well, I'm going to be definitely joining the academy, so um yeah. Okay. And then how do I get a certificate of service? Like you said, can I just make it myself once I
Yeah.
testify that I got the green card?
And make it up yourself.
Okay.
Over that chat GPT.
Okay, perfect. And then I just, put exhibits as like the green card, and then the one that I get from the post office, the printout of the electronic.
Yeah, that's cool.
Okay,
Yep.
cool.
Yep.
All right. Thank you so much, Amir.
Yeah, no problem at all. No problem.
All right, so we have Daryl. You can unmute yourself and put your hand down, please.
That will make Mel the last person.
Hey, this is Daryl. I just had a quick question on the documents we record. Do we record those documents at the county?
Yeah.
Okay, that's all.
If you can't record them at the county, then do newspaper. If you
Mhm.
can't do newspaper, then go to a different county. If that don't work, then try old case. If that don't work, then gonna have to figure it out.
Okay. All right, thanks.
No problem.
All right, and then the last one is Mel. Put your hand down, please, and unmute yourself.
All right. Peace and love, Amir. I appreciate this. You really dropped some knowledge on me, and definitely going to be studying the review and the replay. So I just wanted to kind of bring it to your attention again. We kind of spoken in on Instagram a few times about kind of the situation right now. So basically, I have a eviction trial hearing as it stands now on May 11th. And in this discussion, you mentioned that I should do a bill of quae timid and basically wrap the case up in a trust at that time. Now, I was thinking now, due to the time until trial, I may need help with establishing a private trust and serving the landlord in a judge's chambers. So I guess my question is would you have time to give one-on-one assistance? Because I really want to maximize my chances to resolve this matter in equity on the first attempt. And, I'm able to compensate for one-on-one guidance, if you have time to take the case.
Yeah, I can assign you. I can assign you a case manager, and we can get to it if you don't want to. I mean, that's what you pay for the class for, but you know, if you want that 101 direct guidance, I mean, that's not a problem at all.
Well, it's primarily, it's me and my wife and my 6 children and the landlord. They trying to basically railroad us. They stopped accepting our payments back in January, and they're just basically trying to set or trying to obtain possession. And I really feel like I'm gonna need just extra help and equity because I'm really being done wrong. I've been renting for them for like almost 6 years, and they just got like new landlords, and now it seems like they just trying to railroad us out of here. So I really want to ensure some more time, at least until our lease is up, and then we can move out. Like I ain't really trying to be greedy or nothing. I just want to ensure that the sheriff ain't coming in here trying to kick
Right.
me and my wife and my kids out the jam.
Got you. Yeah, shoot me a message, bro, and we'll get you together tonight or tomorrow. And
Okay.
we basically just follow everything that you know what I mean, we just went over.
Okay, cool. Peace and love.
Peace and love. That is it. Man, I am super glad that y'all enjoyed the class, because let me tell you, been busy and haven't been feeling the best. So I was really trying to make sure I do well today for y'all. So I'm glad y'all had a good time. I'm glad you guys are learning. Glad y'all was tuned in. I just appreciate y'all. This is so you guys will get the replay within 24 hours. So if you don't get it by tomorrow night, send me a message through Eventbrite, because chances are it's a technical issue, or it might be, check your junk folder, spam folder, check all your folders or whatever in your email. But if you don't get it, just shoot me a message through Eventbrite, and we'll make sure that you get everything that you need, that you're entitled to. Again, I'll have templates and reading material in the Dropbox for you guys. As you can see, I'm telling y'all, don't sleep on ChatGPT. You need to go ahead and sign up for the 4.0 versions, like $20 a month. Well worth it. When using ChatGPT, you are going to have to switch out some things, and you are going to have to, if it ever pulls up a case, you need to go research that case, because it could be a bullshit case, a fake case that has happened. So just use it like it's a assistant, a research tool. And don't forget, you are withdrawing the property from the public and depositing the property in the private. Withdraw and deposit. Withdraw from the public, deposit in the private. That's how you extinguish public relations. Transform them from public relation to trust relations. Don't forget to add those things, the statements into your indenture that I mentioned that you need to have in there, that included withdrawing and depositing into the private. Like I tell all of my discussions, this is intended to be a guide, a tool for you to use forever. Like my mentor has, videos, audios Yeah, specifically a set of videos that I've watched probably 50 times over the past few years. And I learned something new every single time to this day. So that should let you know how many times you should be watching, you know, this video and, you know, the ones in the academy if you join. Watch them over and over and over and over and over. The more that you grow, the more that things will sound different to you and make more sense than it did before. It's going to take time. It's going to take dedication, especially if you're new. This is a narrow path, but well worth it. If God be with you, then who can be against you? Faith, the size of a mustard seed, can move mountains. All it takes is one person. Equity will show you that. I promise you. So again, I appreciate y'all for tapping in with me, and that will conclude this equity discussion. And I'll see y'all on Instagram. I might go live here in a little bit. But yeah, we out. I'll see y'all later. Peace.